Welcome to another edition of Crime News with Mark Solomon. It's Tuesday, August 17, 2021, and today we're going to be talking a little bit about some of the collateral issues that are almost certain to come up in the Barry Morphew trial here in Colorado. Had some viewer questions. We're going to be talking about what type of extramarital affair types of issues can either side get into, and to do that, we're going to have to talk about the rules of evidence. Stay tuned. But before we get to that, don't forget to click like and subscribe with a little bell next to it to be notified of future videos. If you're enjoying this video, you want to see more, click that button. You'll be the first to see when they do come out. Okay, let's get to it. I had some viewer comments. People were saying, I'd like to hear more about Barry Morphew and less about the affair. The trial is about her murder. My response to this viewer, me too. However, with 2 of the 4 days of the preliminary hearing out, the issues of her extramarital affair are now at issue, and the real question is, why are they at issue? The next viewer commented, I agree, the affair is just a distraction. I'm focused on the elements of the crime. My response was, I'm going to be very interested in the specific details of proving Suzanne's death and the cause of death. So remember, what we're doing is we're listening to all of the evidence that's being presented in the preliminary hearing, and they have thrown a lot of information into just 2 days of the preliminary hearing. And because this is such a circumstantial case, they are literally putting everything they have into the preliminary hearing so they can get assured that the judge will find probable cause. It's not a certainty in a case that's so circumstantial. They do have Suzanne Morphew's tracks stopping, and they do have his running around the house at about the same time and then delivering some suspicious bags of trash to Broomfield, and that's kind of it. They don't have a body, they don't have blood, they don't have DNA, and so they're trying to make sure that this circumstantial fact that she's dead is much more probable than otherwise. So why are we talking so much about the affair? Well, here, she's tired of the blaming and shaming defense when it's not allowed to divulge the accused person's shady background or prior criminal activities. Because of that question, I wanted to go into the rules of evidence just so that everybody understands this. This Colorado Rule of Evidence 404 is essentially the same as the federal rule, and it is the rule that governs what type of character evidence can come into any trial or hearing where the rules of evidence applies. Character evidence is generally not admissible. You can't prove that somebody robbed a bank because they just tend to rob a lot of banks. It's just not what we like to show in law. The rules of evidence assume that you cannot show that just because somebody is a bank robbing sort of guy that they robbed this bank too. They can, however, use other sorts of evidence to prove that they robbed other banks in a very specific way, that this bank was robbed, therefore the identity of this person is probably the same as that. That's one thing you can do. And there are certain limited times when other crimes, wrongs, or acts can be brought into evidence against a defendant. Like to prove motive, opportunity, intent, preparation, plan, identity, absence of mistake, or lack of accident. Anytime a prosecutor wants to bring that type of evidence against a defendant, they have to give notice, and the defendant gets a right to challenge that, and there's a hearing. And in Colorado, the prosecution has to make that notice with what's called particularity, so that the defense can be ready for that. And the whole purpose of that is to say that a person isn't fighting their past, they're fighting this crime. Now, if they're convicted, then everything that they've ever done can be used against them in sentencing. So there is that too. Now, when we talk about witnesses, on the other hand, it's a different rule. That's governed by 608, the character of witnesses. And in these types of cases, the two things that are always at issue when a witness is on the witness stand is bias for or against either side, or credibility, as in how honest of a person is this. Here in Colorado, they can use convictions of a felony as evidence of somebody's untruthfulness. They can also use honesty crimes that are misdemeanors, like shoplifting or falsification of records, or any sort of conviction where somebody has been untruthful. But let's not get into that much detail and miss the point. The viewer was asking about victim blaming and shaming. So let's get to the actual issue of marriage infidelity. And that's where If the prosecution wants to bring out the evidence that Suzanne was having an affair for the purpose of showing that Barry was jealous and in a rage potentially killed her, that's something that they can almost certainly do. Anytime you can bring out evidence that makes a material fact more or less likely, depending on which side you're on, and I'll explain that in just a second, that side is almost certainly going to be able to do that, as long as it's not an overly prejudicial fact. And, I'm not going to get into that either. So in other words, if the prosecution, if the state can show that Barry Morphew found out about her affair, which makes his killing Suzanne more likely, they'll be able to bring that out. Next question I had by a viewer here at the bottom: would the prosecution be able to keep out his cheating in order to keep a narrow focus on the motive being that she cheated? And this viewer asked because there are a lot of rumors regarding his cheating both in Indiana and Colorado. And the answer to that is probably not. And the reason why is, here, if the prosecution brings out her affair to make it more likely that he got jealous and hurt her, then the defense could bring out his having an affair to show that he was less invested in their relationship and that he didn't care about her extramarital affair, which makes his killing her less likely. So prosecution can bring in one, defense can bring in the other, and then the jury can figure out what they believe and the importance of each of those facts. So I talked about a little bit of this in the last video. If he was cheating on her and it made it more likely that he didn't want to give her money in some sort of divorce case, then that could actually make it more likely that he killed her, if there is any evidence to support that. And part of the answers that I was putting online with the comments from the viewers, which I always appreciate your comments, always do. I read as many as I can. There have been more than I've been able to get to, and I apologize for that, but I'm doing my best. One of the comments that I said was, as long as each side can lay the foundation and the evidence is relevant to a material fact. I keep using the term material fact. What does that mean? A material fact is something that one side needs to prove their case, or the other side needs to disprove a material fact on the other side. And therefore, if they can lay a proper foundation, this can't be speculation, this can't be hearsay, they have to have somebody who has personal knowledge or an expert witness who can lay a proper foundation for an opinion, then that evidence can come in to support a material fact. Otherwise, that evidence will never get heard. Nobody can guess whether or not something happened. They have to know it to be able to testify to it. And if their ability to know that is compromised through cross-examination, then the jury gets to pick and choose which facts they think are real or not. In summary, we've talked about how the Rule of Evidence 404 does not allow the prosecution to prove the character of the defendant. And if they are going to use some sort of character evidence against the defendant, it has to be used for a specific purpose, and the defense gets to challenge that. On the other hand, if they're talking about the character of a witness, that's Rule 608. And that's where each side gets to attack bias for or against either side and the character for truthfulness or untruthfulness. We've also talked about how marriage infidelity on either side can be used to prove or disprove a material fact. So in Barry Morphew's case, her being unfaithful almost certainly to come into evidence if it can be proven, and that's to make his hurting her more likely. On the other hand, the defense probably could bring in his infidelity to make that less likely, because guess what? If he's having an affair of her own, maybe he doesn't care about the marriage, and then he doesn't care if she's cheating on it. On the other hand, though, you've got the notion that if he had assets or if she had assets and her death enriches him, then that would make his hurting her even more likely. And that's what we hope to find out on the other 2 days of the preliminary hearing. And if this goes to trial, which I think is probably pretty gosh darn likely, we'll find out about that in the trial too. So that's all I've got for today. If you've got your own questions, comments, or thoughts, I'd love to hear them in the comments below. And until then, thank you so much for watching.